Welcome, everyone, to the Federal Bar Association Ketam Sections, the Rounds, FCA News with Tejinder Singh. I'm Scott Oswald. I am Program Chair of the Ketam Section. The Rounds is Tejinder's regular analysis of noteworthy FCA decisions. Tejinder is a partner at Sparacino PLLC. Tejinder, hello.
Hey, Scott.
We have big news to share and talk about because the Supreme Court has granted cert under the Safeco Scienter standard under the FCA. And we're going to find out whether and when a defendant's contemporaneous subjective understanding or beliefs about the lawfulness of its conduct are relevant to whether it knowingly violated the False Claims Act. Tell us more about this.
Yeah, this is a big case. This is probably the biggest FCA case since the Escobar decision. It is likely to be to scienter what that case was to materiality. For a couple of years now, defendants have been pressing an argument that if their conduct can be shoehorned into an objectively reasonable interpretation of the law, even if it was in fact illegal, they cannot be held to have acted knowingly. As we all know, the Seventh Circuit embraced that argument. The Fourth Circuit got on board with it for a minute, but then vacated that decision. And now the law there is up in the air. And so we sought certiorari in the Supreme Court about this, and the court has agreed to take up the case. So we'll get an answer one way or the other this Supreme Court term. I think it's going to be a very big deal because in the circuits that have taken the restrictive pro-defendant view, if we prevail, liability would be expanded. On the other hand, in most of the circuits where the standard does look at the defendant's subjective understandings, if the defendants were to prevail here, liability would be constricted significantly. This is a case where the government, the Solicitor General's office, recommended that the court hear the issue and decide it. And I think it's pretty clear from the government's brief whose side they're on. They're on the side of enforcement. So they'll also be weighing in during the proceedings.
So let's talk about the schedule first. What can we expect over the rest of the year?
So the cert grant kicks off a pretty firm briefing schedule. The court's practice is to decide all of the cases granted pretty much through now by the end of the term. So oral arguments will happen in April. Before then, we'll be filing an opening brief. The respondents will file a brief. There'll be a reply brief. Arguments will happen in April, and the case will be decided no later than the end of June.
My guess is there'll be a lot of amicus activity. What do you think?
Yeah, I bet that's right. In these cases, there's already been a flurry of amicus activity in the Court of Appeals level. So you've seen on the relator side, you've seen the government, you've seen Taxpayers Against Fraud, and others who are concerned about the ways that defendants could exploit loopholes to defraud the government. On the defense side, you've seen Chamber of Commerce, you've seen Pharma, and I expect all those folks will show up again here.
So you mentioned the implications here and a number of circuits that have taken this more maybe restrictive positions. Which are those circuits?
So up until now, the ones where I think it's been the most restrictive is definitely the Seventh. The Eighth and the DC circuits also have precedents that go in this direction. There's some ambiguity there about exactly what those precedents hold, but I think on balance, I put them in the restrictive side. The Fourth Circuit flip-flopped. It was in the restrictive side, and then it hopped out, and now it's unclear what's going on over there. But those are the courts that have taken the more restrictive view. And then on the other side, I think there's pretty clear precedent from the Ninth Circuit, the 11th Circuit, the 10th Circuit, that goes the other way and is quite favorable to relators, or at least says you have to look at what the defendant thought at the time to determine if they were acting knowingly.
So let's fast forward to the decision in this case. I mean, what is at stake under the False Claims Act here?
So many False Claims Act cases are predicated on the violations of other laws. So in this specific case, the question is whether pharmacies were accurately reporting their usual and customary prices. And what the pharmacies say is, look, no, we weren't. We were not accurately reporting our usual and customary prices. We were overcharging the government for medicine. But at the time we were doing this, the law just wasn't clear about what usual and customary prices meant. And so you can't say that we did it knowingly. The law got settled, but only later. And so at the time it was up in the air, and we're okay here because we can articulate a reasonable interpretation. The real rub in this case is that the case is in the summary judgment posture, and there is evidence in the record from which a jury could say, actually, at the time, you knew that it was at least more likely than not that this was illegal, and you did it anyway. And the defendant's argument is really, who cares? They say that doesn't matter. If our lawyers today can tell you a reasonable interpretation of the law that accommodates our conduct, that's really all we need. You shouldn't even be looking at what we thought. So you ask what's at stake in the case. It's really that. It's the question of, and this will mostly come up, I think, in the pleading stages. It's the question of when the defendant can make sort of a straight-faced legal argument that what they did was okay, even if we all now know that it's illegal, can they get away with what they did? And that will have dramatic implications, not just for usual and customary price reporting, but for myriad federal programs, regulations, contracts, where there may be some ambiguity that a defendant has exploited to take payments that it shouldn't have.
There's been some other activity in the Supreme Court in Polansky versus EHR, oral arguments on December 6th of last year. What was the relator's frontline argument and how did it fare?
The relator's frontline argument was a straight textual argument that I thought was pretty interesting. The relator said, if the government does not intervene in and move to dismiss a relator's case at the outset under subsection C2A, then it effectively loses the right to do so. And that's because it seems pretty clear from the statute, and I think from oral argument, a majority of the Supreme Court is likely to agree, that the government has to intervene before moving to dismiss. And there's this part of the section about belated intervention, if the government doesn't intervene up front but tries to intervene later, that says that it can only do so if it doesn't compromise the rights and status of the relator. And so the relator argued that means that you can't compromise my right to conduct this action. You can't move to dismiss it. You lose that power if you don't use it right away. The court, interestingly, was completely uninterested in this argument. They just sort of let it go by in oral argument. Nobody really wanted to talk about it. And it seemed to be almost assumed that the government has the power belatedly to seek dismissal. And the questions really centered around how much of a burden does the government have to carry in order to make that decision. Based on that, I think that the government is highly likely to win this case because all of the proposed burdens are really pretty permissive. It's something like rational basis or not arbitrary. And so if the government can come up with a reason, it should be able to get away with dismissal. My prediction based on oral argument is that that's the way the case is going.
So is there any good news here for the relator side as a result of what you heard in oral argument?
We'll have to wait and see the decision to see what the news is. As I said, I do think it's likely that the court will say you have to intervene before dismissing. Belated intervention is also conditioned on a showing of good cause. It's possible that the court would put some teeth into the good cause requirement in cases where the government wants to intervene belatedly in order to dismiss. But until we see the decision, we won't really know if that requirement is going to be beefed up over what it has been previously.
Tejinder, we've also had some activity in our courts of appeals. We're going to touch on 3 decisions. The first case is U.S. ex-rel Ascolese, the Shoemaker construction company. This is out of the Third Circuit. And this is a retaliation case, Tejinder, where the government declined to intervene in the underlying FCA claim. The relator then proceeds just on the employment claim. What happened here?
So it's exactly as you say, the relator pursues an employment retaliation claim and the claim was dismissed. And there are really 2 legal issues that are worth noting for litigants in the Third Circuit and litigants generally. The first is the Third Circuit considered how much notice the employer has to have for the employee to be entitled to retaliation protection. The previous standard in the Third Circuit was understood to be that there had to be a distinct possibility of FCA litigation, and that was the trigger that entitled the relator to retaliation protection. The Third Circuit says, no, after the amendments in 2009 and 2010, it's broader than that because the statute also encompasses other efforts to stop FCA violations, not just litigation. And so if you're reporting internally, if you're taking steps at your workplace to try and stop the violations, that can be enough to put the employer on notice. So that's an important development. An employee doesn't have to have told the employer, I'm going to sue you under the FCA or anything like that. The second piece of it, though, is the flip side to the coin, which is that this employee was in a compliance role. And for employees who are in that compliance role, this is particularly salient. The court says you have to do more than just your usual job responsibilities. You have to, for example, go outside the chain of command in your internal reporting to really draw attention to this. And so that will be an important fact in the case on remand, and it will be an important fact in cases going forward because this precedential decision will sort of govern the contours of how those protections work.
And the relator in that case at least pled the fact that he had gone outside his normal chain of command in some of the reports. And how did the court view that specific averment in the complaint?
Yeah, that was sufficient. In this case, when the court reversed it, it said, we find that the relator has sufficiently pleaded the relevant elements. And it's asked the district court to consider some of these issues in more detail on remand under the correct standard.
Our second case is UX XRL CKD project out of the Second Circuit. This is a public disclosure and original source case. How did this case come up?
Yeah, so this is an unpublished decision, so it won't be precedential, and it's heavily dependent on its facts, but it has some useful teaching points about especially litigation against publicly traded companies. In this case, a publicly traded company acquired some dialysis centers, and the allegation was that they paid an above market price for the dialysis centers, and that payment was effectively kickbacks for the patients in those centers to get them into their system. And so an anti-kickback statute FCA case was brought, and but the defendant had disclosed certain legal risks, including anti-kickback statute and Stark Act risks relating to this specific acquisition in its SEC filings. And so what the Second Circuit says is there was enough of a disclosure of the material elements to trigger the public disclosure bar. And the relator, who had some information about the transaction that wasn't in the SEC filings, was merely adding additional details that were not material enough to either mean that no disclosure occurred or to entitle the relator to original source status. And so it said the case is properly dismissed under the public disclosure bar. The big takeaway is that for relators suing a public company, you really want to look closely at the SEC filings and see how you can work around those. For companies, this is good encouragement to make comprehensive disclosures in SEC filings over and above what the securities laws already incentivize, so that you can claim public disclosure bar violations if somebody sues you under the FCA.
Our last case is US XRL Lovell versus AthenaHealth, and this case dealt with attorney's fees, something that's near and dear to our hearts. What was the issue here? In fact, two issues, Tejinder.
Yeah, there are two. In this lawsuit, there are two qui tam actions brought. The government partially intervened in both, in some of the claims, but not others, and then settled them with the defendant. And then both sets of relators, the first filing relator and the second filing relators, who had filed 2 months later, sought their attorney's fees. And for the first filed relator, the issue was the government had only intervened in one of his claims, but he wanted the attorney's fees that his lawyers had done for all of his claims. And the court said, no, you're not entitled to those under 3730 D1, which is the provision that entitles you to a recovery in cases where the government intervenes, because we deal with that on a claim-by-claim basis, not a lawsuit-by-lawsuit basis, and they only intervened with respect to that claim. Interestingly, the court left to the side the question whether the relator could have pursued his fees for the second claim, the non-intervened claim, under 3730D2, which is the provision that entitles you to compensation for your non-intervened claims. The court said that he had effectively waived that argument, and so it didn't reach it, didn't talk about it at all. So the lesson for relators in the future is if the government only intervenes in one of your claims, claim your entitlement to fees under both provisions after a settlement, and you'll have a better shot than the relator did here.
And then the second relator, right? That the second relator didn't fare even that well.
No, so for the second filed relators, they wanted their attorney's fees as well. And the way the settlement was structured was very important to the court's conclusion that they weren't entitled to fees. In effect, what happened is the United States settled with the defendant, and the defendant paid money to the government. The government then paid money to the first filing relator only. The first filing relator and the second filing relators had a side deal whereby the first filing relator paid over a portion, and it wasn't disclosed how much, to the second filing relators. When the second filing relator sought their attorney's fees from the defendant, the court said, you're not entitled to those because getting your attorney's fees under the statute is predicated upon you receiving a relator's share from the government. And because you didn't get your share from the government, you got it from the other relator, you're just not entitled under the statute to recover your fees. Again, the case is kind of most notable for what the court doesn't decide. So the court says, we're not saying that the only person who can get fees is the first filing relator. And we're not saying what should happen in cases involving differently structured settlement agreements. So if the settlement agreement in this case had said the defendant pays the government and the government pays both sets of relators, we're not saying that there would be any problem in that case either. We're only saying that when you do it this way, through this intermediary of the first relator, then second relators, you can't claim your attorney's fees. So again, this is just a lesson, I think, in how to structure these transactions and agreements. If you're a second filed relator, you'll really want to press for receiving a share directly from the government and not only from the first filed relator, so that you can preserve a potential entitlement to fees. Although to be clear, it's not guaranteed you'll get the fees. It would be litigated in that circumstance, but at least this precedent wouldn't bear on it.
Tejinder, thank you. And thank each of you for joining us for this edition of the Federal Bar Association Key Tam Sections, the Rounds FCA News with Tejinder Singh. We'll see you next time.